Muted.
We want to welcome you, ladies and gentlemen, to a GableGotwals sponsored webinar that is talking briefly about some new decisions and pronouncements from both court cases and agency decisions or agency pronouncements. I'm Leslie Lynch. I'm a shareholder in the Oklahoma City office, and with me today is Chris Thrutchley, who joined GableGotwals recently in our Tulsa office. And Chris you were the director of the successor to the Oklahoma Human Rights Commission, is that correct?
That's right. We ran the Office of Civil Rights Enforcement for the Attorney General's office.
Okay. And in that position, Chris was the lead person in charge of enforcing Oklahoma statutes that mirror a lot of the federal statutes that we're going to talk today. But now he has left that position and returning to defending employers, which is what he did for years before he joined the state. As part of this seminar today, if you'll look at your screen, you have a picture of a hand. If everybody will click on that, that will indicate to us that you all can hear us. And then we know that we can go forward with the substance of the presentation. So if you'll all click your hand, make it point up, then we'll know that we are successfully transmitting. See a couple of them working. Okay. You can download the PowerPoint presentation today. You should have been sent or will be sent some written materials that go along with it. That, you know, PowerPoint sets forth things in really summary manner. There's some written materials that actually use full sentences that explain these concepts. And then the third thing, if you have a question as we're going along, there's a question button on your screen. You can type a question, and we will attempt to answer it as it relates to the subject matter that we're discussing. Now, if your question is one that is very fact-intensive, that would require a discussion back and forth, we probably won't answer that as part of this hour-long seminar because we just won't have time, but we would be happy to talk with you after the seminar. Either Chris or myself can give you a call to discuss that. So as we begin, we're going to just jump into this. It is a large number. It's a large number of topics, and we're going to focus on each of these for just pretty quickly. So we're going to talk about all of the big things that usually hit HR people. We're going to talk about religion. We're going to talk about pregnancy. We're going to talk about wage and hour matters. We're going to talk about social media issues, which is becoming a bigger topic, Fair Labor Standards Act. So as we go along, hopefully you'll find something that's very helpful. In 2015, the United States Supreme Court decided a case called EEOC versus Abercrombie & Fitch. If you are a person located in the Tulsa area, you probably saw a lot about this case in your local newspaper because it arose in Tulsa. It arose in the Abercrombie store that's in one of the Tulsa malls. And it was about religion. It had a young lady that applied to work at an Abercrombie store. She came into the store, filled out her application, wearing the traditional Muslim headscarf, seemed to do really good in her interviews, was qualified on her application, but didn't get the job. So it came down to why did she not get the job, and the question was it because of her religion? And was she treated differently because she appeared to be someone that practiced the Muslim religion, or was it something else? The technical test is a disparate treatment. The employee, and in this case the EEOC on behalf of the employee, had to show that she suffered an adverse employment decision. It was made because of the employee's religious or religious practice. Now, it's not the only way to prove religious discrimination, but it is one way that we can prove religious discrimination. She has to show that she was treated differently than other employees who were similarly situated, and that the treatment was based on her religion. So, in general, here's what adverse employment decisions are. They're failure to hire, terminating somebody, demotion when it's accompanied by something substantive. They have to receive fewer wages, a less distinguished job title. It's not transfer to a different shift if that doesn't affect somebody's pay. It's not giving somebody different job duties unless there is something of substance that goes with that, or it could be a failure to promote. The case, the EEOC case, the Abercrombie case, the proof or the issue became, was it because of her religion? And part of what we learned in that case is Title VII's intentional discrimination provision prohibits certain motives on the behalf of the employer regardless of what the actor knows, regardless of what the employer knows. Motive, meaning why you did it, and knowledge, meaning what is in your mind, are separate concepts. Unlike the 10th Circuit, we had a decision from a judge in Tulsa, a federal judge, I think it was Tulsa, and then it was an appeal to the 10th Circuit who found for the employer, and then they took that up to the United Supreme Court. The United States Supreme Court said the employer doesn't have to have knowledge that the characteristic or practice is a religious one, only that the employer knew or at least suspected that the characteristic or practice was for religious reasons. So this was an example. Abercrombie has a look policy. They want all of the people that work in their stores to look alike, to dress alike, to wear their clothes, and they had a policy that prohibited wearing caps. So was this head scarf a cap, and was it because of her religion? When the 10th Circuit decided this case, the EEOC's expert said, we don't know why she was wearing this. Nobody can say, religion, looking at me, you don't know what my religion is. You don't know what my deeply held personal belief relating to my God is, because it's something that's personal. People wear things that could or could not be religious for many, many purposes. And he said was specifically related to the plaintiff in the Abercrombie case, it could be that she was wearing this headscarf because of her religion, but it also could be that she wanted to separate herself from Western culture. And we don't know because there was no discussion. So as employers, you're going to have to start making these decisions, and I want to show you a little quiz to see how you're going to do when you start having applicants come to your place of business. I'm going to show you 3 slides, and at the end of the slides, I'm going to ask you, based on these 3 slides, which of these individuals could you safely say, I'm not going to hire you, and I'm not making a decision based on religion? Okay. Here's the first quiz. Here is the first item. So if somebody has this on a tattoo or on a T-shirt and comes to apply for your place of business, can you safely say, I'm not going to hire you because you're wearing that? That was slide A. Here is slide B. And here is slide C. So the quiz. If 3 job applicants show up for an interview wearing or displaying a shirt or jewelry or a tattoo with one of the foregoing images, which one can you safely, meaning without liability, decline to hire because of the image? I'll tell you in answering it, the first one is a Wiccan pentagram. It's the 5-pointed star, or it's called the pinnacle if it's inside the circle. The second one was the Jewish Star of David. And the third one is a Satanist pentagram. It's the 5-pointed star, but they're pointing down, or a pentacle again if they're inside of a circle. So with that explanation, I'll tell you, you cannot refuse to hire any of them because of the display of those images. Each of those symbols is a representation of a religion that is actively practiced in Oklahoma. Certainly they're not Southern Baptist religions. They're not any of the others that at least I grew up in, small-town Mustang 30, 40 years ago, but those are actively recognized and actively practiced religions in the state of Oklahoma, and we cannot make employment-based decisions based on representations of those religions. So here's another quiz. It's going to be the same question at the end. Here is image A. Here is image B. And here is image C. So the question is, if the job applicants in the preceding 3 slides showed up to apply for a job with your place of business, which one could you safely, meaning without liability, decline to hire because of the image? Well, the first one, which was the picture of the young woman's hands with the henna tattoos, is not a religious concept. It is a celebratory rather than a spiritual or religious. It's similar to dressing the bride and doing a makeover and getting a manicure in the United States. The second one is a religious aspect. It is the Church of the Flying Spaghetti Monster. They are called Pastafarians, and part of their religious practice requires them or suggests to them that they should wear a pasta strainer upon their head. If you've been around Oklahoma for a while, you saw that there was a woman maybe 5 or 6 years ago that insisted she be allowed to wear her pasta strainer on her head for purposes of her photograph on her driver's license, even though the state of Oklahoma prohibits wearing any kind of head covering on driver's license photos. I think that's for law enforcement so that we know what color hair and it doesn't shade somebody's eyes so we can see their color of eyes. But she was permitted because it was a religious practice to wear a pasta strainer on her head for purposes of her driver's license photo. And then the third one were crosses of various sorts, which are both a symbol of Christianity and simply, in many instances now, a secular decoration. So this would go and depend upon the employer's motivation for the employment decision. Was it because you thought it was a religious practice or not? Now, according to the Supreme Court, this is where I think there's going to be some litigation in the future. The Supreme Court said in the Abercrombie case, while knowledge requirement cannot be added to the motive requirement, it is arguable that the motive requirement itself is not met unless the employer at least suspects that the practice in question is a religious practice, i.e. that an employer cannot discriminate because of religious practice unless he knows or suspects it to be a religious practice. So I think if we start getting into instances like the Church of the Flying Spaghetti Monster and someone appearing wearing a spaghetti strainer, that somebody thinks might be a religious practice, that we have some room left on what needs to be litigated. But other than that, I think employers are going to have a duty to become more knowledgeable about what is required and what is suggested and what are typical practices of various religions that are practiced in Oklahoma. And I'll tell you, it's a very, very broad spectrum of things that can surprise you. One of the cases that's up on appeal, I checked just a few minutes ago, the Supreme Court is considering whether to grant certiorari review. The briefs, which probably only excites us lawyers, were circulated last week, so they're deciding whether they're going to hear a successor case to Abercrombie. In this case, there was a young woman that worked at a nursing home, and one of the residents was Catholic, and she asked the activities aide, would you please pray the rosary with me? The activities aide refused and told another aide, I can't do it, it's against my religion. The next day, the resident complained to the management that she'd made this request and that she was refused. Management responded by writing up the employee and subsequently fired her. The jury found in the employee's favor, gave her $55,000. The Fifth Circuit Court of Appeals reversed, saying there was no evidence in the record that the management knew prior to terminating her, because she was a bad employee otherwise, that the employee refused because of her religion. In 2013 or 2014, I guess it was 2014, 2015, the Supreme Court reversed the Fifth Circuit and said, let's do this over. The Fifth Circuit maintained the same position, saying that there is no knowledge, using that quote I used before. So now that's back before the Supreme Court. Do they have to know that the employee did or didn't do this because of her religion before there's liability on the employer?
A couple of things for me on the religion topic, Leslie, I think that are key takeaways for employers and HR managers, and what do we actually do with Abercrombie in the cases that follow. One, and I think it's the smaller of the two issues, but it's a big practical takeaway, and that is, what, if anything, do we do differently in the hiring process in light of Abercrombie? The second thing that I think is really huge, that goes way beyond Abercrombie, is this whole idea that that Scalia emphasized in Abercrombie regarding motive. So let's talk briefly about the hiring process. One of the things I think employers need to seriously be considering, if they haven't done it already, is you gotta train your hiring managers and supervisors on how to be alert to these kinds of issues that could arise in the hiring process. And if they do come up, and they're rare, it's not often that you get somebody in the hiring process that could have a potential religious accommodation issue, but it could come up. And so have you trained managers and supervisors to be equipped to effectively deal with that kind of issue in a way that minimizes your risk that somebody's going to accuse you of being motivated by their religious belief when you didn't select them for a position? So training. Another thing that I think is a good practice is to anticipate the kinds of things that could come up and script for them. Have your managers and supervisors trained that if somebody volunteers an issue that's a protected class factor, like religion, if the religion issue comes up in the hiring process, then just have something scripted like, you know, we don't really consider religion a relevant factor to be decided in making a hiring decision, but can you help us understand how you think that might be relevant to our decision? And then that way you can demonstrate, if you ever get hit with a lawsuit for failure to hire, that you have a legitimate, non-discriminatory approach to how you handle religious discrimination issues that come up in the hiring process. Another way that you could script that potentially is if somebody makes a request for a religious accommodation in the hiring process, then you can have a scripted approach to it that says, yeah, we have a policy where we will gladly evaluate whether or not we have the ability to accommodate, you know, your sincerely held religious beliefs. Let's walk through that. Help us understand the situation and where you see a conflict with our policy. But one of the problems with the Abercrombie case was this was a teenage girl. She has no clue what a reasonable accommodation is for purposes of her religious beliefs, and would have no way of knowing that she needs to make that kind of request in the hiring process. That was one of the issues that the courts on appeal wrestled with. So a possible adjustment to the hiring process employers could make to try to nip this issue in the bud before it comes up is think about, in your hiring processes, is there a place where it would make sense and where it would be efficient and reasonable to provide notice to, maybe you've narrowed your candidate pool down to a handful of the best qualified candidates and you're going to bring them in for interviews. Well, think about providing them a copy of your job description, provide them a copy of your employment policies that may include your dress code, as in the Abercrombie case, and then provide them a copy of your policies that emphasize how you do consider reasonable accommodations for disabilities or for sincerely held religious beliefs. And then ask them, when they come into the interview, having read your policies, having read the job description, then you're prepared to ask them that scripted question. Are there any reasons why you would not be able to adhere to our dress code policy or our other employment policies? And if they don't have any reason, great. You can check that off, that you covered that base in a lawful way. If they do have something they believe requires accommodation, now you're in a lawful position to be able to engage in that discussion of a protected class factor without creating the appearance that you have a motive or a bias against that person. I think those are just some practical steps that employers could take in response to Abercrombie in a way that can help them minimize risk that their hiring decisions look like they might be motivated by bias.
One thing Chris said just triggered a thought with me. He said you need to show them that you have a policy, that you provide a reasonable accommodation for disability. Well, we've been doing that for several years, and hopefully that process is working. But also for this religious discrimination, to allow someone to display indicia of their religion if that's what they're supposed to do. What does that tell us as employers? That we need to go back probably and look at our handbooks and our policies to make sure that that's in there. That we try to write a handbook and a policy manual that is a timeless document, but several of the things that we're going to talk about today suggest strongly that this is now a good time to change and to look at reviewing it. There are enough new things that are coming up that employers need to sit down and look at their handbook and have some trained legal eyes look at your handbook to see if we see problems in the way that things are written.
Yeah, one thing I see, Leslie, is that in accommodation policies, they typically don't have much detail regarding the procedure. Like, how do you make the request? What should the request include that can help the employer navigate the issues intelligently? And when the request is made, what's the balance of the process that the employer is going to go through to help evaluate whether or not an accommodation is reasonable and can be granted? I think those kinds of things are good to have in the policy too. But the hiring issue to me is really the least likely issue employers are going to face in response to Abercrombie. It could come up. They need to be prepared for it. But to me, the biggest factor in this case was the pronouncement regarding motive. You know, historically, we always thought, you know, if the employer doesn't know they've got a religious belief, or if an employer doesn't know that they fall into a certain protected class, then how could they have had an improper motive? And to me, this emphasis on motive in Abercrombie goes way beyond to every employment-related decision that an employer could make. And it creates this whole issue, brings to the forefront this whole issue about the mixed motives theory. So an employer could have 5 reasons that are great, legitimate, non-discriminatory reasons why they're going to discharge somebody, or why they're going to demote somebody, or why they're not going to promote somebody. But if there's evidence that one of the reasons might be motivated by an unlawful bias, then you've got a mixed motive discrimination claim that has risk of getting beyond summary judgment, and now you've got to try what the real motivating factor was, the 5 that were good or the 1 that was illegal. And so to me, that puts employers in a position where they really need to think about practical ways that when they go about making an employment decision, whatever that decision may be, that they can establish all of the legitimate non-discriminatory reasons why they made that decision. So for instance, in a discharge context, maybe not allow that frontline supervisor or manager to make a unilateral discharge decision. Instead, require that to go through an approval process where multiple people are reviewing and evaluating the bases for that decision and vetting it for whether or not there could be the appearance of an improper motive. I mean, usually a lot of times in the employment context, you know, we know when a certain manager or supervisor can tend to come off like they have a bias. I mean, look at the thing that Trump just got hit with today in the news about the staffer that's saying, well, he's discriminating against me on the basis of my sex. I mean, we see what the emails are people send around and the jokes they tell, the kind of nicknames they use. And if we tolerate that, they can have 3 or 4 great reasons for making an employment decision, but that evidence, circumstantial evidence of bias, could be enough to create a mixed motive claim. So coming up with ways in decision-making processes to eliminate or minimize the risk of the appearance that there's some unlawful motive behind that decision.
Right, and I think one of the things that's going to involve is training of managers, employees, and stopping the jokes, stopping the nicknames, stopping all the things that we have been able to argue as employers counsel for a long time. If it's random, if it's just a little thing here or there, that it's not going to establish liability. But I think going back to what Chris says, if you have 5 good reasons, but it's the employer that has used derogatory terms to refer to this person's religion or gender or something else, that might be enough to get past summary judgment under this case.
Abercrombie illustrates it well, because the decision maker had legitimate non-discriminatory reasons based on their interview evaluation criteria to not make the hire. But the frontline manager told the decision maker that she believed that the reason she wore the hijab was for religious reasons. And that very fact that there was a belief out there was enough to get it beyond summary judgment.
Okay. We're going to go through pregnancy. Title VII, this was added in 1978, that you cannot discriminate based on pregnancy. But 40 years later, almost 40 years later, we're still struggling with it. We had decisions about what you can allow in your health insurance plan and what you can't. We had a decision in the 90s about a woman that worked at a battery manufacturing plant, and they wanted to say any woman of childbearing years cannot work in this inherently risky job, because if you get pregnant, it most likely will cause harm to your unborn child. You can't do that. But most recently, it was a pregnant woman that needed light duty. She was working for UPS, needed to have some of the restrictions on how much she could lift on the boxes she was delivering placed on light duty because she was pregnant. UPS gave light duty assignments almost routinely to anybody who had a workers' comp injury, anybody who was disabled under the ADA, and any of the drivers who had lost their DOT certifications. But the employer didn't treat pregnant women any different than they did a guy that had gone skiing on spring break and blown out his knee. If he needed an accommodation and he couldn't work, that was too bad. He didn't fall into categories 1, 2, 3. He didn't get an accommodation. Pregnant women were treated the same as the guy who got hurt on the ski lift. Consistent with prior rulings, I would have said I think that's a pretty good defense. The United States Supreme Court said that's different. Looking at UPS and the size of UPS and the number of accommodations they gave to the people in those 3 categories, they're saying, yeah, not good enough, employer. You're going to have to show that there's sufficient, they're saying the plaintiff showed that there was sufficient evidence that the policies imposed a burden on pregnant workers, and that they, because they accommodated so many other people. So is the failure to accommodate a pregnant worker, is that causing a significant burden on pregnant workers who want to work for UPS? So they let that case go forward. Big change in the landscape, and I think it was dependent in part on the size of UPS, that they had sufficient personnel. You know, accommodating a pregnant worker is only going to last for, at best, 9 months until that woman has birth. It's not going to extend beyond that, because we don't carry babies any longer than that. It doesn't usually start from day 1, although it might under certain circumstances. But since it was a limited time period for which they would need accommodation, and the size of UPS, I think the Supreme Court said you're going to have to do something more.
Yeah, Leslie, I think a huge takeaway from the Young versus UPS case is train your managers and supervisors on the accommodation process, including how to accommodate pregnancy-related conditions. And in that training, emphasize to the frontline managers and supervisors, never say never. In this case, there was an HR manager that she went to request light-duty accommodation like all the other employees got. And the HR manager said, hey, we don't do that for folks in your category. And the HR manager very easily could have said, you know what, let's take a look at that and we'll evaluate that together. And then the HR manager could have gotten with legal, and they could have gone through all the processes they normally go through to evaluate it, and maybe they would have reached the same decision. But up front, with regard to that face-to-face contact with your employee, I would encourage employers to train their people to have the attitude that is, how can we help you? Let's walk through this together. You may ultimately decide you can't accommodate her. It's not a reasonable accommodation. But as to that employee, up front, begin by saying, how can we help you, instead of saying, we don't do that. The other thing I think that's important about this Abercrombie, or I mean the Young case, is pregnancy and ADA are both strategic enforcement priorities for the EEOC. So if folks get charges of pregnancy discrimination or ADA charges, it's going to receive priority attention by the EEOC. So it behooves employers to be proactive now in taking steps to try to minimize risk of these types of claims. And so in the final analysis, my suggestion would be treat pregnant employees the way you would treat any other employee that has any kind of physical limitation, regardless of these categories that we used to draw in the past with respect to workers' comp-related injuries or things like that.
Real quickly, this one is not a big deal, but as related to pregnancy, many women breastfeed their child and they need to pump when they come back to work. The Affordable Care Act tells us that you have to give the employee, the woman, it's only going to apply to women, obviously, a reasonable break time for the employee to do the pumping for 1 year after the child is born, and a place that's not a bathroom, that's private, got a lock on the door where she can do that. The frequency of the breaks, nobody says it's once in the morning, once in the afternoon, on her lunch hour. It's going to vary by employee. Bathroom will never work. It can be a temporary space. It's nice if there's a permanent space that can be made available to all the people, but you don't have to. You don't have to pay her while she's in there expressing the breast milk. And if you want them to work an 8-hour shift and they take 30 minutes to do that, you can make them stay 30 minutes on the end of the day and do that. That is fine. But you can't make her take a computer, a laptop, some piecemeal work or anything else in the lactation room to do that with her. She has to be completely relieved of duties. We are about halfway through our time and not anywhere close to halfway through our slides, so we're going to start kicking this up a little bit. Under the Fair Labor Standards Act, there has been, what is compensable time is a big deal, especially for employers that require employees to do certain things before they start working or after they stop working. So there are a lot of legal terms that really don't make sense, even to lawyers, until you start applying them to facts. So we're talking about preliminary and post-preliminary activities as they relate to the principal activities that you've hired somebody. Principal activities means the things you've hired somebody to do, what are integral and indispensable part of what you've hired somebody to do. So if it's something that the employee can't not do and still perform their job, then it becomes integral and indispensable. So what does this mean? A case that came out in 2014 was Integrity Staffing versus Busk. A company provided warehouse staffing employees to Amazon. So every time one of us goes on Amazon.com and places an order, the employees of Integrity Staffing in this warehouse went to the shelf, got the item, put it in the box, put our label on the box, and shipped it out to us. As a result of them having access to so many small things that could be easily stolen, Integrity Staffing required employees to go through a post-shift security screening that could last, on average, 25 minutes a day. So once they finished their 8-hour shift, they had to go through this screening for 25 minutes a day. The employees had asked, can we have staggered shifts so that we're not standing in line so long? Can we have more security staffing at the end of the shift so there's more people to get the employees through? And they were told no. So in turn, they turned around and sued under the Fair Labor Standards Act, saying you need to compensate this. So are the security screenings a principal activity? And the court said clearly they're not, because the employees were not hired to undergo security screenings. Are they integral and indispensable to the employee's duties? No, they could do their job without doing this. This was a thing that benefits solely the employer and Amazon to make sure employees weren't walking off with stuff off the shelves. But they said it wasn't compensable time. which is kind of surprising that, and our court is kind of favoring employees right now, but this decision went against the employees. So here's some more examples. Battery plant employees spend time showering and changing their clothes after working around lead and other toxic chemicals. Meatpacking employees had to spend time sharpening their knives before they went in and started butchering the meat. Poultry plant employees waiting to put on protective gear. Or another factory employee spent donning, putting on, and removing protective gear. So are those compensable time? And what this matters is one person paying them for another 5 or 10 minutes a day is not a big deal unless you have 10,000 employees that are doing this, then it really adds up. So the battery and plant employees, that time was compensable. The time that they spent showering and removing the lead and toxic chemicals from their bodies and changing clothes was compensable time. So the employers have to pay those employees hourly, or if you're in excess of 40 hours, you have to pay them overtime to take a shower. The meatpacking employees, that was compensable time because the court found sharpening those knives allowed the employees to be more efficient, get better cuts of meat, and was part of what was required of those employees in order to do their job. But the poultry plant employees waiting to put on protective gear was not compensable time because that was not something that was integral to their job function. But the time putting on the protective gear, so not the time you're waiting to do it, waiting for your turn to get in the locker room, I guess, but the time you spent putting it on is compensable time. So that's a pretty fine line to draw, but it's been drawn by the court. Pretty clear. Go ahead.
I'd just say briefly, Leslie, if you've got employees that you think may fall into this category where there could be compensable time they're performing before or after work, but you're not sure, think about the Amazon employees. How many of us, if we were required by our employer to spend 25 minutes going through this security check, would not think we ought to get paid for that time? I think a lot of us would probably, our gut would tell us, you probably ought to be paying them for that time. Now, integrity staffing had a good result, but the reality is this is an area of huge, huge risk for employers. So I would just say, weigh the risk. What's your risk tolerance? Are you willing to take the risk? Or do you feel like you've got sufficient risk that you need to go ahead and consider compensating employees for that time? It's a cash cow area for plaintiffs' lawyers bringing wage and hour class actions because it's not a scenario that's likely going to result in summary judgment where you can get out early. And so it can be a very costly area. So just weigh the risk.
And there's significant penalties because you pay the employees back for the time they spent, and you're also liable for 2 or 3 years of equivalent damages as a penalty. So it can add up very, very quickly. I'm going to move forward. In one of these cases, the court had to decide let's see where it is. The person had to put on a hard hat, a snood, wristlets, gloves, glasses, earplugs, leggings, steel-toed boots, and an air respirator. What of those is clothing and what is something else? Because the time spent putting on clothing was compensable, but the time putting on other things was not. So it can be a very, very technical issue, and it's something that certainly would behoove you to spend a little bit of time with your counsel to ask these questions for if you're in that situation of requiring somebody to do something before they start their job. It's well worth that couple $100 that it's going to cost you. Now, the Department of Labor has taken to implementing some interpretive rules that don't go through a legislative process, but they're going to be enforced, and they're causing some issues to employers, but they're not going through a legislative process where you can have comments on them and they can be subject to, let's make this better, let's make it fair for employees and employers. One that came out recently was attacked in Perez versus Mortgage Bankers Association. These were people that were in-house mortgage lenders working in a bank or some other place that were being compensated on a percentage of what they were bringing into the bank on a commission basis. Years ago, they said that was fine. The Department of Labor said that was fine, and they can be subject to the administrative exemption under the Fair Labor Standards Act. Well, in 2010, they reversed that, and they said that those employees do not qualify for the administrative exemption. They need to be paid as hourly employees for the first, for 40 hours, and then any time after that at time and a half. What made that a big deal was some of these people had been highly compensated because they were really good at what they had done, and they were earning commission checks that were pretty big. But when they were determined that they were supposed to be hourly employees, and there was litigation, and there was a guy out of Missouri, I think, that just started picking off these banks, hitting the big ones first, and then making his way down and suing on behalf of all the mortgage loan officers in those banks. They calculated what these employees' hourly rate should be based on those commissions, and then determined how much time and the unpaid wages that were due these employees were astronomical for some of these banks involved in this litigation. So what does that mean for employers? Not only is this interpretive guideline only applied to mortgage bankers and whether or not they fall under the administrative exemption, but the Department of Labor is issuing more of these on a routine basis. So you need to stay abreast of what is being issued, and you can do that by having a relationship with counsel so that we can let you know, or start reading the Department of Labor's announcements when they issue a new administrative interpretation, or you've got to find it out and you've got to start following, because it's going to make a huge bottom line impact. Let's see, where are we? We've got about 18 more minutes. Unpaid internships. This is a less of a impact in Oklahoma because we don't have, as a routine basis, unpaid internships, whereas in New York City or other places there's more of them. There are some people that have unpaid internships in the practice of law. Some people will say, you can come intern for me, I'm not going to pay you because you need the experience that I can provide you as a practicing lawyer. There are a few others, but it's not a big deal. But if it is a practice of yours, you're a healthcare provider or somebody else that might do this, the questions that need to be asked before you don't pay these interns are somewhat specific. You're going to have to look at a number of factors, and here's 7 on this slide, and they're very fact specific. Not one of them, if you satisfy number 1 but lose on the other 6, it still doesn't tell you whether you need to pay this unpaid intern or not, but it's a balancing test. So looking at things about what does the employer and the employee understand. Do they understand this is going to be an unpaid internship? If you have suggested that if this works out, we'll move you to a paying job, then you're probably having them be an employee. Are they getting training that they would get in school, or are you having them do work that should be done by an employee? Is this done through an educational program, or is it a law school, a nursing school, sending you someone that's going to work for you for a semester and they're getting credit? That's more akin to an unpaid internship than somebody who says, hey, I'm getting a PR degree, but I want to come intern for you. Is that okay? If the school is involved, it's more of an indicia that it is a legitimate internship rather than somebody trying to take advantage of a student. How does this work with the academic calendar? Is it a limited period of time, or are you going to say you can do this for me for 3 months, 6 months, a year, or is it open-ended? If it's open-ended, it's more like an employment relationship than an internship. Are you using this intern to complement the work being done by your employees, or are you getting an intern because you pay an employee? So if the intern is doing the job of an employee, you should be paying them. And then the last one is there a suggestion that at the end of the internship you could get a job? The next topic is sexual orientation and gender identity. And this is a new focus of the EEOC. They've been filing lawsuits on behalf of transgender employees. They filed amicus briefs in several cases, and they have issued a federal sector decision for federal employees applying and determining that Title VII provides protection to people in the LGBT category. The EEOC recently said discrimination related to LGBT status is prohibited under the laws the EEOC enforces. While Title VII does not explicitly include sexual orientation or gender identity in its list of bases, the Commission, consistent with case law from the Supreme Court and other courts, interprets the statute's sex discrimination provision as prohibiting discrimination against employees on the basis of their sexual orientation and gender identity. The EEOC said this has been longstanding and facially apparent from the text of Title VII. I don't agree with that part. I certainly agree with them when they say this is and should be a protected basis, but I think it was stretching it to say that it's longstanding and facially apparent. But be that as it may, whether I want to quibble on that, the law is, for now, we are going to see sex meaning not only because you're a man or a woman, but it's going to include sexual orientation and gender identity, and that is, there's not going to be any question about that.
Leslie, I think it's critical for employers to train managers and supervisors on how they're going to handle this kind of issue, even though technically they're not required to modify their policies to add sexual orientation and gender identity as protected classes. I think the last stat I heard, like over 90% of all Fortune 500 companies have done that, but under Title VII, technically it's not required. Under Oklahoma law, technically it's not required. But practically speaking, for the last 15 or 20 years, we've always trained managers and supervisors that in the workplace, regardless of whether or not it's a protected classification, they should be very careful to make sure two things. One, whenever they make an employment-related decision, someone's sexual orientation or gender identity should be completely irrelevant. They should base their employment-related decisions on knowledge, skills, ability, experience, business factors, job-related factors, and don't go near that sexual orientation or gender identity motivation because there's risk. The other thing is, when it comes to harassment prevention training, they've got to be trained on how to balance the differing concerns of those that have genuine moral or religious motivations and convictions versus those that take the position of sexual orientation and gender identity being appropriate. Those can easily blow up into harassment claims. And so just managing in the workforce the need to demonstrate and model and require mutual respect for differing opinions. Then the bathroom. The bathroom's always the biggest question we get. What about the bathroom? And the EEOC's position is you got to accommodate the bathroom requests. And so I think the wise approach today is encourage your folks to be accommodating to each other and not get into fights over the bathroom.
Which may be easier said than done, but this is the law and this is what's going to be applied. So you have to be firm in that advice, and if necessary, again, consult counsel on how to do that. This is also a place where you might want to check off and look at your handbooks. Chris said you don't have to put that in there, but if they're going to start enforcing that, think about whether you want to include that in your handbook as a basis on which we don't discriminate. It also impacts benefits issues. If you haven't already looked at your benefits issues, you need to do that. The next to last topic we're going to talk about is improper classification of employees as independent contractors. And this could be easily a topic in and of itself and really cover a half a day because it's that detailed. And it's that big a problem. We had a company come to us last year that wanted to let somebody go, and I said, well, we need to talk about the age of this employee, and he says, oh, no, they're not an employee, they're an independent contractor. I said, how are they an independent contractor? He said, all of my employees, or all of the people that work for me are independent contractors. I said, with all due respect, you may be treating them as independent contractors, but I can guarantee you the person that is answering your phones and opening your mail and doing routine matters like that does not qualify as an independent contractor, even though it's easier to pay them and to do all of the employer-related stuff, doesn't make them an independent contractor. It's a very specific test, and it is very fact-intensive of when somebody is an independent contractor. And again, the issues if you are paying somebody or treating somebody improperly as an independent contractor when they should be employed are multiple. You have wage and hour issues because you should have been paying them potentially overtime. You may have benefits issues. You may have taxing issues because you didn't deduct the employer's portion of the taxes from the wages that you paid them. You may affect what you've done on workers' compensation. If they're driving, they may not be covered necessarily under any liability policy that you have that covers your vehicle. So it is a broad-ranging impact on employers to determine if these people really are independent contractors. What they have done is look at the economic realities of this relationship. Are the workers economically dependent on the employer regardless of their skill level? Can the employee continue to make a living if they're not working for you? And that really oversimplifies it. So what we're looking at, is the work an integral part of the employer's business, or are you having somebody come in because you need to start a new computer program, so you've hired an independent contractor that's going to come in and implement a new computer system for you? That is not probably an integral part of your business. It's something that needs to be done to upgrade your computer system, but it's not part of your day-to-day business. Does the worker's skill affect his opportunity for profit or loss? Is he going to make more money if he is successful in doing what he's doing for you, or is he going to make less money if he doesn't do as good a job? Does he have investment in the task at hand, or is it the employer? Or is he bringing his own tools to the job, for example? Does it require special skill or initiative? If you hire a geologist to come in and do some specific work, they have some specialized skill and initiative that maybe a regular person doesn't. How long is this relationship occurring? Is it a indefinite, or is it, I need you to do this for 3 months? And then what is the nature and degree of the employer's control? Are you saying, I need you to do this project, here is the deadlines by when I want it finished, and things like that, giving them general guidelines? Are you saying you need to come in at 8 o'clock on Monday morning and you need to start on this task, and when you finish that one, you do this task, and when you do that task, you finish this one, and I need you to do it in this manner? And so those things indicate more that it's an employee instead of an independent contractor.
me, the big takeaway on this, Leslie, is DOL has recently announced that they are going to make misclassification a major enforcement initiative. And so that means that employers have risk that they're going to get hit with an audit in this area. And it only takes one complaint by an employee to the Department of Labor to open up a massive can of worms. And as you mentioned, the liability is huge. You got tax liability, benefits liability, compensation and overtime liability potentially. You're not going to get summary judgment on these kinds of claims. They're incredibly costly to defend. And we all remember Microsoft years ago paying millions and millions and millions of dollars to these, quote, independent contractors who were doing IT work right next to their employees doing the exact same job. So folks need to evaluate the risk and just weigh their risk tolerance when it comes to whether somebody really is a contractor.
Right, and it's another topic for another day, but the DOL is also looking at and heavily investigating whether people are properly paying as hourly or as exempt employees. But again, that's another topic for another day. So I think the last issue we have to talk about is NLRB and social media. For a long time, we didn't think the NLRB had anything to do with most of the employers, because that talks about the National Labor Relations Board, and most employers are not unionized employers. So why are we talking about that today? And what we want to say is the NLRB has made itself relevant to your employment situation because of how they are enforcing their policies. 20 years ago, we didn't have to worry about social media policies because nobody knew what that was. But now, almost every employee has a Facebook page, or they tweet, or they can do one of these other things, and employers don't like people saying negative things about them in a manner that can be broadcast to anybody who wants to read it. So the NLRB has come down against social media policies and said, you know, you have to think about a social media policy as controlling the electronic water cooler. How can we control what employees are saying or aren't saying electronically in a manner similar to how we can talk about employees talking about things at work? So what they have said, the policies, the social media policies, cannot be so broad as to prohibit discussions of wages, working conditions among employees, or other activities as permitted by federal law. But an employee's gripes on Facebook that are merely gripes about mundane things are not, can be regulated by an employer's social media policy. The policies cannot prohibit an employee from talking about on Facebook something that went on at work. But how do you tell employees, how do you explain this to them, what is or is not permitted? And the best is some examples. We've got in here, there was a social media policy that said you cannot engage in inappropriate discussions about the company, management, or coworkers because you might be violating the law and subject to disciplinary action. The NLRB found that this policy was not permissible because what is an inappropriate discussion? How is an employee supposed to know what is an inappropriate discussion? They said that was overbroad and it was violating the regulations. So they looked at another one. It said communications should be kept professional and respectful. Well, that sounds a lot better. That sounds like we're telling them what they can and can't do. And then another part of the policy is employees who share unfavorable written, audio, or video information can be subject to discipline. But the NLRB said both of those are too vague to inform the employees as to what is permissible and what is not permissible. Here is a policy, on the other hand, it's Landry's, that the NLRB said was fine. And they said it was fine because it explained to the employees in language that's understandable what they can or can't do. and they focused on the language underlined in red. This can be accomplished by always thinking before you post, being civil to others and their opinions, and not posting personal information about others unless you have received their permission. So the NLRB said this one was fine because it was narrowly tailored, it avoided words or phrases that are arguably ambiguous, it used examples to clarify what it meant, and it was pretty specific as to what they didn't want somebody talking about. None of these policies have made it through a court decision. What we're talking about is what the NLRB has done, and it's going to take a little bit of time for these to trickle through the court process where we have a judicial determination as to what is or is not acceptable. But right now, I would recommend to all employers that you revisit your policy and you look at it and you think, does this really tell my employees what I don't want them to do? And if you don't understand what it means, you probably need to rewrite your policy.
Leslie, what a lot of employers fail to realize is that the National Labor Relations Act has always covered all employers regardless of whether or not they have a unionized collective bargaining unit in their workplace. And the National Labor Relations Board is the agency that's charged with responsibility for enforcing the National Labor Relations Act. And Section 7 of the Act is the provision that prohibits employers from, and this is key language for the non-unionized employers of the world to be alert to. Section 7 prohibits any employer, unionized or not, from interfering with or restraining in any way the employee's right to act together in regard to wages, hours, and working conditions. Those are the three kind of magic categories: wages, hours, and working conditions. And so what the National Labor Relations Board has done recently is, because of the decline in unionism in the United States over the last several decades, the National Labor Relations Board has gotten very aggressive in trying to interpret the cases before it in a manner that expand its reach to those non-unionized employers. And so what happens is, it all comes down, I think, to the way employers are administering these social media policies or administering other policies that the board has recently attacked, like a recent case where they said a no recording in the workplace policy violated Section 7 rights. I mean, how many employers, a lot of employers, have no recording in the workplace in light of smartphones and things like that, taking video or audio recordings, or striking down a no media policy, where a policy that prohibits employees from reaching out to the media about things, or confidentiality policies, declaring confidentiality policies that would say you can't share confidential company-related information with the public as violating Section 7 rights. And so what the National Labor Relations Board has said is there's a standard disclaimer policy that employers can adopt, that they can incorporate into their handbooks, that says basically that regardless of how our policies are interpreted, we comply with Section 7 of the National Labor Relations Act, and they're not meant to interfere with or restrain an employee's exercise of their Section 7 rights. So you want to have a disclaimer policy in there to go along with your other traditional policies. But I think here's my suggestion. When employers go to administer their policies, if they believe, for instance, somebody has posted something on Facebook that could violate their social media policy, look at the content of the posting. Is that employee just disparaging a supervisor without any real apparent justification? Or if you look at the content of the post, does it really come off like the employee is concerned and expressing concern to other employees about wages or hours or working conditions? Maybe there's something that manager or supervisor that is allegedly doing that is impacting working conditions. Those things are topics that fall under the protection of the National Labor Relations Act, and so in that context, an employer would want to take care with regard to how they enforce that policy, because an employee could file an unfair labor practice charge against the employer alleging that they are interfering with and restraining and their right to engage in protected activity under the National Labor Relations Act. So I think for me it's an issue of balance. It's so important to have all of these kinds of policies that we're talking about. But don't put things in there that say like, you shall never post on social media, or you shall never talk to the media, or you shall never record in the workplace. Instead, qualify it. Have some qualifying language in there that doesn't interfere with or restrain concerted protective activity. Have your disclaimer provision in there regarding Section 7 rights. And then when it comes to enforcement, just evaluate carefully whether somebody could argue that they're dealing with wages, hours, and working conditions.
And even more than that, just evaluate the risks of how big a deal is this really going to be. Sometimes employees are going to rant about something about Facebook, and it goes on for a day or a day and a half, and their friends see it, and that's it, and it's over and it's done. Do you want to risk, by enforcement of a policy that may be facially valid and facially permissible, do you want to act upon the employees posting on Facebook when it's really over and done? Think about that. Weigh the risks of what is an enforcement action, what is an LRB action going to cost and take and versus time, and is this a matter really, really over? Okay, we have been notified that we've gone over our allotted time. We really appreciate those of you that have attended. Please, if you have any questions about today's seminar, would you give Chris a call in our Tulsa office or reach out to me here in the Oklahoma City office, and we'd be happy to answer any questions that you have, or happy to look over your handbooks or your policies or give you any specific advice on any of these topics we've covered today.